In today's episode, we're going to talk about the pros and cons of California's Assembly Bill 5 and how it has impacted businesses and workers alike. So don't forget to subscribe and turn on the notification bell so you stay up to date when new episodes come out. The labor market is constantly changing, from legislation establishing new minimum wages to new laws around data privacy. But perhaps the most impactful recent change, at least in California, is Assembly Bill 5, AB 5. What exactly is this bill, and how will it affect your business? So let's dive into that in today's episode. First, what is AB 5? AB 5, also commonly referred to as the Gig Worker Law, went into effect January 1st, 2020. It left little doubt in anyone's mind that most workers are and should remain employees. As a result of the law, it's likely that many independent contractors will be reclassified as employees. Here's how it works. Businesses, employers must consider new hires as employees and not independent contractors unless a new hire meets all of the following criteria. Number 1, the worker is free to perform services without the control or direction of the company, both under the contract and in fact. Number 2, the worker is performing work tasks that are outside of the usual course of the company's business activities. Number 3, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. For example, a driver who is an independent contractor for a ride-sharing service, but also offers the same service through his or her own business. The law could affect workers such as meal delivery and courier drivers, ride-sharing drivers, and owner-operators of big trucks, to name a few. On the other hand, it provides exceptions for positions such as physicians, attorneys, architects, insurance salespeople, and accountants, among others. So then what triggered AB 5? The answer you'll frequently hear is that it's the result of today's app-based, independent contractor-fueled ride-sharing services. As the Washington Post states, Assembly Bill 5, which passed the California legislature in September, aimed to give hundreds of thousands of gig economy workers employee status, providing wage floors and benefits along with worker protection. So in essence, proponents of AB 5 want to force companies to reclassify independent contractors as employees, so that these workers are legally entitled to minimum wages, benefits such as health insurance, and even breaks. So what is the issue for employers? Employers could obviously lose the relatively affordable labor of independent contractors with their flexible schedules and lack of benefits. For those employers who have routinely used independent contractors, this could have a big impact on the business, as it could significantly balloon their payroll and other HR-related expenses. These costs can't simply be absorbed, they must be offset somehow. Will businesses be forced to pay less than competitively in their market? Will they utilize temporary workers? Will they have to shrink their workforce? It's too early to answer these questions, as AB 5 is currently mired in a tangled legal web. Already, companies are suing the state of California, not to mention a judge just temporarily blocked the law from affecting truckers, and that's the tip of the iceberg. More legal battles are just as inevitable as they will be tense. So what are the pros and cons for workers? For independent contractors turned employees, they're legally guaranteed the aforementioned benefits and perks, so they gain a sense of security. While that goes a long way, there is a big loss. Most independent contractors choose to operate under the classification because it grants them an immense amount of flexibility. They're able to work whenever they please, which can be far more attractive to some than a strict, repetitive schedule. It seems that the majority of contractors have issue with AB 5 and refuse to embrace it. SB Nation Executive Director John Ness recently wrote, "In the early weeks and months of 2020, we will end our contracts with most contractors at California brands." In response, SB Nation contractor writer Rebecca Lawson tweeted, "Today, along with literally hundreds of my colleagues, I was told that I can no longer hold a paid position at SB Nation. California, you're breaking my heart and taking my money. Hashtag AB 5. In the above example and countless others, the law serves to suppress job growth that voluntary self-employment creates. So then what should your business and staffing partner do? Recognize that AB 5 is in a state of flux. Yes, the law passed, but there are many legal battles attached to it. Some companies are taking a wait-and-see approach, while others are considering converting independent contractors to permanent or temporary W-2 employees. There's even speculation that a new class of worker could be born. It's really a messy ongoing battle with lots of potential effects, so make sure you stay tuned in. So thank you for listening to today's episode. More to come, and as always, take care of your money.